Okay, welcome to episode 3 of the Gorry Show. It's a weekly show where I look at essentially legal information, legal updates that I come across on my Twitter feed, and obviously I make some comment or other on them, which might be of use to you if you have an interest in Irish business or Irish law. So, as I say, it's a weekly look at my Twitter stream, a particular Twitter stream that I've set up for legal issues and legal tweets. First one I noticed there is Lidl is ordered to pay 17,000 after demoting a manager to clerk following misconduct claims. So there was a disciplinary situation and this man was accused of misconduct. One was to do with, I think, theft of a 2 litre of milk or something like that, and the other was something to do with falsifying work records. I don't know whether the allegations against him were proven or not. They may have been. He was disciplined in a normal way in accordance with the disciplinary procedure. However, he appealed it, and apparently when he appealed it, then he had been a manager for many years and he was demoted down to some sort of a clerk job, which resulted in a €17,000 loss per annum, and the Labour Court found that this was an excessive or disproportionate penalty. Sorry, just to clarify that, it wasn't 17 grand per annum that he was going to lose, but the Labour Court in their decision awarded 17,000 to him against Lidl. So that's where operating manager, was demoted on misconduct allegations. Another interesting tweet there about an executive whose yearly earnings have topped 275,000 at the recruitment company CPL Resources has failed in her unlawful wage deduction claim against the company. Don't know the details there exactly, but obviously a well-paid executive, whether if you were on 275 grand a year, would be bringing any sort of a legal action against your employer for a so-called unlawful deduction or not, be entirely a matter for yourself. Obviously it would depend on the circumstances and it would depend on how much of a deduction. But if I was on that sort of money, I myself on a personal basis would be slow enough to rock the boat. That's just me. There's a tweet there by another solicitor on about a WRC decision where again it's a classic example of how not to run a disciplinary investigation. So the employee was awarded, doesn't say how much the employee was awarded, but won his or her WRC case. And again, it's an example of a situation where an employer has simply lost a case for failing to provide a fair disciplinary procedure in accordance with basic fundamental principles of natural justice, constitutional justice and fair procedures. If an employer doesn't do that, they're going to be in difficulty every single time when they go to the WRC if they're facing a claim. There's an interesting article there as well. I see it in a tweet about a solicitor being penalised for correcting their own mistake. I had a quick glance at the article there this morning. It's to do with the solicitor making a mistake in a family law dispute in the United Kingdom and then trying to remedy the mistake and actually making matters worse insofar as the client wasn't happy with the outcome, even though the solicitor, in trying to remedy the mistake, actually provided something like 30 grand sterling worth of legal services for free, but ended up then with a professional negligence or claim or a professional complaint against the solicitor. And apparently this particular case may have impact here for solicitors because it will have persuasive effect and it will give rise to questions for solicitors if they are holding their hands up and saying, yes, I made a mistake, accepting that there may well be a professional negligence claim in the pipeline, but trying to remedy the situation then by taking some other steps. In other words, the solicitor is doing what would appear to be the right thing to do, holding the hands up, admitting liability, admitting guilt and trying to remedy the situation. This case is actually a discouragement from doing that, and it may well have persuasive authority in Irish law. It's a UK case, interesting one. The Irish Human Rights and Equality Commission, I think it is, are just tweeting there that if you have a complaint about discrimination or harassment in the workplace, then you make a complaint to the WRC, the Workplace Relations Commission. There's another interesting tweet there about claiming tax relief in employment settlements. The whole question of settlement agreements and agreements to settle a legal dispute in employment situations, or indeed in any situation, but in employment situations in particular, has very significant tax consequences. And quite frankly, you'd want to be getting, if you are the recipient of a settlement in relation to any claim that you might have brought, or in relation to perhaps a redundancy or a purported redundancy, or even a claim of discrimination in the workplace or a claim of harassment, and then there's an agreement, a settlement agreement. The whole question of taxation in that situation is a complex one, and one that you really do need to see a tax consultant about, not just a solicitor. There's an interesting point there as well made by another solicitor, that any settlement agreement, if it is to obtain relief in accordance with Irish tax law, cannot have a phrase in it without prejudice or no admission of liability, or without admission of liability. If that's the case, then it's not liable, or it's not entitled to obtain the tax relief that you'd be looking for. But I would reiterate that it's a complex area, the whole question of settlements and taxation, and I would always recommend that you get advice from a good accountant who is well into taxation, or indeed a qualified tax consultant. And if your package is big, if your settlement agreement is big, definitely spend a few bob and get the advice from a tax consultant. Another tweet there about a case, or the general principle that legal representation in dismissal cases isn't generally allowed. This is an article, or a topic rather, I've covered quite a few times in my website, employmentrightsireland.com, covering a particular case involving a Mr. McKelvey and Erin Road, Éireann. Basically, the case went to the High Court, and I think it went to the Court of Appeal. Not sure whether it went to the Supreme Court or not. The bottom line is that an employee is not necessarily entitled to legal representation in a workplace investigation or disciplinary procedure. There is exceptions, all right, but by and large, generally, a solicitor is not entitled to go along to either a disciplinary or an investigation. That's worth bearing in mind, because it's something I'm regularly asked to do, and leaving aside the cost altogether of getting me to go along for a day or half a day in some place, the employee doesn't actually understand how much it's actually going to cost them. But the bottom line is there's no point anyway, and I can't go and don't go and refuse to go simply because there is no point. The employer is entitled to say no, you can have a work colleague or you can have a trade union representative. That's it, and that's all you're entitled to really in Irish law, unless there's exceptional circumstances. The exceptional circumstance may be if you are going to definitely lose your job, or there was some serious allegation going to be proved or found against you, which would call into question your character or something of that nature. But by and large, workplace disciplinary investigations and procedures should be carried out without the need for legal representation. That's not to say now that legal representation or legal advice should not be obtained beforehand and afterwards, but just representation in the actual procedure itself isn't an entitlement. A lot of employees don't understand that and expect solicitors to be able to go along and represent them. That's not the case. There's another interesting tweet there about using the internal grievance procedures. You do not have to use them before issuing an equality claim. So there's a recent Workplace Relations Commission decision where an adjudication officer held that an employee should have used the internal procedure in either harassment or sexual harassment or equality situation, a discrimination situation. In that particular case, the WRC found that the employee should have availed of the internal procedure. But previous cases previous decisions of the Labour Court have found that that's not necessarily the case. So there's a bit of uncertainty in that area. But generally, as a general proposition, my view when I'm advising employees at all stages would be to avail of the internal grievance procedures or internal procedures, whether it's harassment, bullying, sexual harassment, grievances or whatever, and even avail of an appeals procedure, simply because if you go along then to the WRC or the Labour Court or the civil courts and you're asked, did you avail of the internal procedures, then if you say no, you're going to be having to explain why not. because if you feel that bad, if you feel, fundamentally you were screwed essentially in the workplace, in the whole procedure, then you'd have to wonder why you didn't appeal it. Now, having said that, you may well not have appealed it because you knew that the outcome was a foregone conclusion, and you knew that the appeal may well go to perhaps the spouse of the person against whom you made the complaint or whatever. But the bottom line is, from the optics point of view, I would recommend that you as an employee avail of the internal procedure that's available to you, whether that's a dignity at work procedure or a grievance procedure or anti-bullying or sexual harassment or whatever. I see a tweet there about a former deputy primary school principal from County Cork has been struck off the teaching register for downloading and distributing thousands of obscene images and videos of children, toddlers and babies. It's unbelievable that would be the case, that a person in such a position of responsibility and so on would end up as a deputy principal, but unfortunately that's life. These things can happen. I see the Chief Financial Officer then with the Irish Greyhound Board. He's seeking to halt a disciplinary process against him, claiming it is flawed, lacks independence and breaches his contract of employment. This would be a case now where a chief executive earning, I think it's 119 grand a year or something like that, big money, is going to the High Court essentially to ask the High Court to stop the disciplinary procedure against him on the basis that he's not going to get a fair shake, etc., etc. I think the case will adjourn until next week. He's the Chief Financial Officer, and there's an issue there to do with overdraft interest on accounts and the purchase of a gift voucher by a company using a company credit card for a departing colleague. He was summoned to a disciplinary meeting, Chief Financial Officer of the Irish Greyhound Board. The application then came before Mr. Justice Tony O'Connor last week, and after inviting parties to consider going to mediation, the judge adjourned the matter to next week's court hearing. So clearly that's probably going to go ahead next week unless there's some sort of mediation or some sort of a settlement agreement in the meantime. Interesting. Again, if you have big money or if you have good salary, etc., and your reputation is at stake and so forth, you may well be minded to go to the High Court and look for an injunction to prevent a disciplinary situation going ahead. It's not guaranteed though that you'll be successful, and it will cost you a right few bob if you go to the High Court looking for an injunction, because injunctions in the High Court, or indeed anything in the High Court, is not cheap. Another interesting tweet there about forced retirement and the whole question of retirement age, justifying retirement age. How do you do it? There's a particular procedure that you need to go through if you're an employer. If you're an employee, you need to get legal advice if you're being asked to or being told that you're being retired. It's a minefield of an area there, and there's been quite a few fairly high profile cases decided by the WRC in the not too distant past. For example, the one against RTE by I think Valerie Cox, and there may well have been another one where the employees won basically that they shouldn't have been forced to retire, and they won a significant amount of discrimination or compensation on the grounds of I think age discrimination. I hope you find this video useful. If you do, give it a thumbs up down below. I think that's about all I have this week in the Irish legal world, and today is Saturday the 8th of February and it's election day. I would encourage you to go out and vote. Give this video the thumbs up if you find it useful. Thanks for watching.